свої місця у залі. Сенсі, щоб він виступив.
Я привожу прем'єра, він одразу
Я зараз їй скажу, щоб вона просто перше сказала.
Ну, да, щоб коли з'являється прем'єр-пресів, вона одразу надає йому слово, він виступає, вона йому дякує і ми йдемо.
Окей, добре, зараз передам. Да, окей, я зрозумів. Щоб ми одразу, щоб ви одразу не висловили.
Так і буде. Так і буде.
Один. Ladies and gentlemen, please take your seats. Шановні учасники конференції, будь ласка, займайте свої місця. Ми продовжуємо.
Людей звідти якось.
Я розумію зараз. Буду там кричати.
Ще раз кажи і кажи, що...
Я можу сказати, ну, так ваше. Я можу сказати, що у вас на спеціальність.
Ну так, що за хвилину буде спеціальний.
Просимо, щоб вони... Що раджу зробити? Там просто мікрофон. Спеціальний гість, прем'єр-міністр України.
Вони тут не чують, для них це нічого не значить. Давайте я зроблю.
I'm sorry, we have a special guest. We cannot wait. Ladies and gentlemen, please proceed to the room. I'm sorry, don't take your room.
Да. Ladies and gentlemen, we have a special guest. We cannot wait. Please take your seats as soon as possible. Шановні учасники конференції, будь ласка, займайте свої місця у залі. Ми маємо спеціального спікера, який, на жаль, не має багато часу. Тому, будь ласка, займайте свої місця. Ці люди вже на своїх місцях. Питання в тому, як оцих загнати.
Там повне. Ну, ще раз треба повторити.
Ladies and gentlemen, one more time. We cannot wait. We have special guest. Please, take your seats. Thank you.
Я зараз піду вже за шефом. Попередьте ще раз модератора, що вона представляє, надаємо слово і по закінченню дякую. І все.
І він виходить.
І він виходить, бо в нас немає.
Добре, я зараз і скажу. Так, добре, окей. Sorry, when Prime Minister ends, he will stand up and go. He don't have time to be here till the end.
No, he delivers his speech and
So
he leaves.
you say thank you and he is good.
Yes, of course.
Thank you. Я не протоколіст, поняття не можу. Ladies and gentlemen, this is the last call. Please, take your seats. Шановні учасники конференції, будь ласка, займайте свої місця у залі. Ми розпочинаємо за 30 секунд. So I think we are ready for the next panel, and the point of this panel is international cooperation in the field of freezing, seizing, confiscating of assets and compensation for damages. And panelists are Irina Mudra, Deputy Minister of Justice of Ukraine, Christos Giacomopoulou, Director General of Human Rights and Rule of Law Council of Europe, Vladislav Lasyuk, Deputy Head of the Task Force Ukraine, Markian Kluchkovsky, Advisor of the Office of the President of Ukraine, Ivan Horoditsky, UBS Board Member. Moderator of this discussion is Tinatin Joletiani, International Law Expert for Ukraine Task Force USAID-funded support to anti-corruption champion institutions in Ukraine. So, and our special guest for this panel is Prime Minister of Ukraine, Denis Shmyhal. So we are waiting a few moments till Mr. Prime Minister come to our room. Probably I need to say something, so I will remind you that we will have a dinner tonight at 8 p.m. And this dinner will be served at the restaurant on the second floor of our hotels. If you want, I can check. So, ladies and gentlemen, Denis Shmyhal, Prime Minister of Ukraine.
Шановні колеги,
Dear colleagues, the microphone is working, so dear friends, dear partners, dear ladies and gentlemen, we all know that Ukraine shall prevail in this war. We believe that we shall be able to liberate our lands, restore our territorial sovereignty, and that will be our common, our shared victory. But the full victory of Ukraine can happen when we rebuild our homeland, when we will bring all the murderers, all the rapists, all those who've looted and destroyed our country to account. Only justice can bring lasting peace. It can bring fairness. And it is our shared responsibility to create the fundamentals and prerequisites for accountability and justice. The two key objectives on this path is the creation of the International Tribunal to bring the political and military leadership of the Russian Federation to account. Secondly, it is creation of the forfeiture accountability mechanism that will be forfeited and used to recover Ukraine. We started documenting the crimes from the early days, all the damage inflicted by the Russian terrorists on Ukraine. Together with the European Commission and the World Bank, we have institutionalized the mechanism. We now have a reliable, transparent tool to assess the damages and the funds that will be recovered for recovery. It's going to exceed $700 billion in equivalent value. We are now verifying the losses with the World Bank and other partners. It's a colossal amount, as the damages are colossal, and they've been brought in by the obvious cause, the Russia. And as aggressor, Russia has to pay for their crimes. And this is fair and just. So we are working in seeking the right tools. There's no ready-made playbook that we can follow. On the course, no existing mechanism, no international treaties, organizations, or laws or tribunals would bring in such a speedy result and the repayment. So we can't trod a beaten path. We have to create and lay a new path, and we have to lay it together. Following the full-scale invasion of Russia into Ukraine on the 24th of February, our allies have seized the sovereign assets of the Russian Federation and the funds of the Russian oligarchs, politicians who have supported, aiding, and abetting the armed aggression against Ukraine. According to previous expert public assessment, the value ranges from $300 to $500 billion. In EU alone, it is assessed at 300 million euro, including sovereign reserves of Russia and 19 billion funds belonging to the Russian oligarchs have been frozen. The concept of the working group is about creating a comprehensive system for recovering the damages inflicted by Russia. And I'm talking about the recovery damage inflicted to the individuals and companies, legal entities, and the state of Ukraine as well, which is now shouldering the burden of making the payments, making compensation payments, and helping people have cover their medical costs, covering the burial fees and all the other expenses. We have to take a record of all these expenses and make the aggressor pay. It is played that this international compensation mechanism will be done through an international treaty, which Ukraine is drafting together with its partners. This treaty will have a fundamental provision that Russia is accountable for aggression, Russia is accountable for the ruination and hostilities against Ukraine, and Russia has to recompense the damage damages. The international compensation mechanism shall have 4 components. The first element is the International Register of Damages that will serve to document the evidence, the information about the claims about the damages, ruination for all the individuals and companies and for the state of Ukraine. So this register will compile all the evidence of the damage inflicted. Secondly is the Compensation Commission that will consider the compensation claims inflicted by the Russian Federation on Ukraine. Thirdly is the Compensation Fund that will make the payments. The fund will be replenished from the forfeited assets of the sanctioned Russian physical and legal entities and from the sovereign assets belonging to the Russian Federation. The fourth element is the mechanism for the implementation of the decisions made by Compensation Commission. We clearly see that in order for this entire system to be put in place, we need to work very closely with our partners to make it happen, with European countries, the UK, the US, Canada, Japan, and a number of other countries that have already stated their support to Ukraine in holding Russia to account, in particular for repaying the damage inflicted. The transfer of Russian assets and using for Ukraine recovery was already made by Canada. Amongst the European countries, it's Estonia, which has taken a very proactive stance in defining what's going to happen to the frozen assets belonging to the Russian Federation. Early 23, intent was declared to develop a legal act for the forfeiture of Russian assets in the nearest future, and we welcome the decision. We welcome the intent. We are fully supportive and hope it can happen as soon as possible. In U.S. budget, there is an initiative provided which would allow the U.S. to forfeit the funds of the Russian businessmen and transfer them for the benefit of Ukraine. At the EU level, the work has started along 2 important vectors: the criminalization of the violation of the sanctions imposed by the EU and also return and recovery of the assets. Moreover, we are leading by example to demonstrate the importance of the matter. We have forfeited 17 billion hryvnia of Russian funds of the Russian banks, which were liquidated in Ukraine following the start of the full-scale invasion. And this is just something that has been contributed to the budget. There are other forfeited assets that will have to be managed accordingly. The fundings will be channeled, and that's 18 billion approximately, and they will use to restore the housing for the Ukrainians. The High Anti-Corruption Court, following the claims filed by the Ministry of Justice, a number of cases are heard about the forfeiture of assets of the Russian promoting aggression and aiding and abetting aggression. A number of assets have already placed in the management of ARMA. The government has decided to pass a resolution to sell the forfeited Russian assets through transparent electronic auctions, which is very important. That will ensure the revenues to the state, and it will also create opportunities for the Ukrainian businesses. And also it's a matter of transparency above all. Dear colleagues, dear friends, the Russian war against Ukraine has brought on unspeakable suffering, ruination, and tragedies. All Ukrainians have been robbed. We shall not forgive, we shall not forget. So the only thing we can do is win in this war and restore justice, punish the perpetrators and rebuild Ukraine. We shall always remember, we shall always commemorate those who have given their lives for our freedom, for our independence. We are grateful to our armed forces. I would like to thank all the participants for standing with us. I'm grateful to our partners for standing with us as long as it shall take. Thank you for your attention. Thank you for your contributions, and I know that we shall succeed. We shall prevail in this war, and we shall see justice. Glory to Ukraine, glory to our heroes.
Thank you very much. I have to go because I have to proceed with other commitments, and I wish you fruitful work. I'm very sorry to be with you for a short period of time, but I really wanted to participate in this panel in order to stress the importance of this issue for us, for Ukrainians, and definitely for our partners. I think that this is the foundation for the future system of global security, for all the potential aggressors in future to know that they will be held accountable, and how it will be in case in future anybody will try to launch this brutal and unprovoked aggression. So this is the important element as we build the future security of our world. Thank you and wish you fruitful work.
Oh, yes. Thank you, Prime Minister, very much. I think it was Prime Minister very aptly put emphasis on issues that are important and provide us some kind of a roadmap through which we should move, which is the justice, accountability, and the need to reconstruction of Ukraine in the swift and comprehensive manner. Also, it's very important that was noted, and it's very core part of this panel's discussion this late afternoon, that there is no ready model how to do it. Rather, we all have to think outside the box and find the custom-made approach, how to ensure that the reparations are paid and the compensations are provided for victims. Once again, good late afternoon, Your Excellencies, ladies and gentlemen. This panel, we will be focusing on the questions of asset recovery as well as compensation. And before giving floor to our brilliant panelists, and this will be the longest panel of the conference, so stay put. We also have the online panelists. I just want to underscore that the concept of the reparations as such under international law is an indivisible part of justice and accountability. Back in 1928, the Permanent Court of International Justice noted that the whole idea of the reparations that they should wipe out the consequences of illegal acts. As far as it is possible. And for 100 years now, nearly, this principle, this concept has been the cornerstone principle of international justice and international relations. And this is what we are discussing. What are the best alternatives to ensure that Ukraine and Ukrainians are getting compensation and are getting reparations for the caused by the aggressive war of Russian Federation, which in the process of this war violates nearly all rules and principles of international humanitarian law. And during these 2 days, we have been discussing and seeing with our own eyes those violations. What needs to be done? How this should be done, and how to use the Prime Minister referred to the frozen assets worldwide and their number. How to use these assets, how to repurpose these assets, that these assets are given to Ukraine, so both for the compensation as well as for the reconstruction needs. Now, to start with our panelists, I would like to first turn to Madam Irina Mudra, the Deputy Minister of Justice of Ukraine. And just want to underscore that Madam Deputy Minister is not only the person who is implementing the state policy on the asset recovery, but she is also one of the driving forces on establishing the compensation mechanism that Prime Minister has discussed. And in this regard, Madam Mudra, I would like to ask you to go into further details of what Prime Minister noted. What are those building blocks on which the compensation mechanism policy of the Ukrainian government is based? Thank you.
Thank you. Thank you, Tina. Good afternoon. I am not heard. No. Yeah. Good afternoon, colleagues. It's really difficult to speak after the Prime Minister because you've just heard all the KPIs which was set up by the Cabinet of Ministers before the Ministry of Justice of Ukraine. So I'll try to elaborate a little bit on these KPIs. Dear ladies and gentlemen, dear colleagues, dear friends, I'm very pleased to welcome you here in this conference. For 1 year, we all been living in a new reality. We Ukrainians, in a country that is exhausted economically, resourcefully, and morally by an unprovoked illegal war, where the aggressor is trying to intimidate us with brutal force to wipe our freedom-loving nation off the face of the earth, where every day each of us is under the risk to lose a son, a daughter, a mother, a father, a friend, a husband, a wife. In a country that is for 1 year used to living in constant air alarms under the threat of indiscriminate and usually deliberately targeted missile and artillery attacks on civilian infrastructure, blackouts, and suffer from large-scale destruction and devastation worth, as you have heard, hundreds of billions of dollars. And you, our dear international foreign partners, you live in the world where there is a place for aggression, where one state can commit an act on aggression against another sovereign, smaller sovereign neighbor, grossly violate basic human rights, commit the most horrific war crimes, disregard international legal order. Actually, that is a state terrorist. And at the same time, successfully hide behind the permanent seat in the Security Council of United Nations, enjoying the benefits from the international financial system through receiving financial returns from Europe and enjoying the benefits of the customary international law, such as the principle of sovereign immunity protection, making its assets abroad safe and untouchable. Do we, the governments of democratic states that declare their commitment to the values of democracy, human rights, rule of law, want such an order to be preserved for the next generations? We, Ukrainian government, no. Ensuring the implementation of a comprehensive system of accountability is a key priority for the government of Ukraine and Ministry of Justice of Ukraine on the legal battlefield. As it was already presented by the panelists and colleagues of mine yesterday and today, the system of holding Russia accountable must be comprehensive and include 3 main pillars: investigation of Russia's war crimes by Ukrainian criminal justice system and foreign law enforcement bodies in foreign states, investigation and prosecution of war crimes, crimes against humanity, crime of genocide by the International Criminal Court, as well as to bring Russia to responsibility in the courts. Ukraine has launched several interstate cases in both most important for justice institutions in the International Court of Justice and European Court of Human Rights. The second pillar is the creation of a special tribunal for the crime of aggression against Ukraine in order to investigate and prosecute the highest political and military leadership of Russian Federation. The recovery of reparations from the aggressor, including creation of the international compensation mechanism, strengthening of sanction measures, confiscation of state assets of Russia and sanctioned individuals, and repurposing them to the compensation mechanism, to the compensation fund, which is which will be created under the compensation mechanism. This money, these assets, the proceeds of these assets will go directly to the victims of war crimes, to the state of Ukraine for reconstruction. While the first two pillars mainly aimed at bringing the individuals, those who ordered this crime to start this war, those who executed these war crimes, to individual criminal responsibility, the latter is designed to recover reparations from the state that committed internationally wrongful acts and provide our nationals with an comprehensive and effective compensation mechanism, and the state as well. So when the war started and we lawyers began frantically searching the available legal forums and means where to go and how to get effective compensation for the damage caused by the war, we understood that the modern international law is unable to provide a ready, comprehensive solution for that. That is why we had to construct the approaches to the compensation mechanism basically from the scratch. And the government of Ukraine launched an innovative approach and presented it to our allies. Months of business trips by working group around the world, dozens of personal meetings with representatives of international organizations, parliaments, governments, hundreds of working Zoom meetings hours. We were convinced, and we convince and continue to convince our partners from various countries with a large number of Russian assets that it is important to start this process now. And while at the end of 2022 we were pleased to receive support from the United Nations General Assembly, for parliaments of many states, Parliamentary Assembly of the Council of Europe, NATO, European Parliament, the Committee of Ministers of the Council of Europe, we have already seen the first but very, very practical result. The launching of the International Register of Damage is now being commenced, and it will be seated in The Hague. And I would like to thank the Prime Minister of the Netherlands, Rutte, and Deputy Prime Minister, Minister of Foreign Affairs, Hoekstra, for this decision. And I also want to thank the United States Agency for International Development, and personally to the Chief of USAID New Justice Program, David Vaughan, for being with us all this long way, for supporting us materially and with expertise. Thank you very much. The UNGA resolution recognizes that the Russian Federation must bear the legal consequences of all of its international wrongful acts, including making reparations. So, want it or not, it has the obligation under the international law. The resolution also recognizes the need for the establishment of an international mechanism for reparation and recommends the member states to establish the International Register of Damages. The resolution was backed up by the concept, which was developed by Ukraine, and Prime Minister just described this concept, with the help of the eminent international and national lawyers. The compensation mechanism is envisaged to provide for the establishment of the Claims Commission, or, well, I would say compensation body, whether it will be Claims Commission or Compensation Commission, especially dedicated to determine compensation claims. The compensation fund from which the compensation shall be paid out, and an effective procedure of the enforcement of the Commission's decisions. And in order to ensure legitimacy to the Compensation Commission, to address the issue of Russia's responsibility in the situation when we lack the consent of Russia to make reparations, and to empower the Commission with the function of adjudicating claims, it should be based on international treaty. The launch of the Register of Damage of Ukraine for Ukraine is the most important element of the entire mechanism. The entire database will be collected, on the basis of which compensation will be paid out in the future. The register would collect information received from individuals, businesses, municipalities, legal entities, both private, public, the state, and record evidences of damage, loss, or injury, and other violations of international law committed by Russia. This evidence to be used in future adjudication process. The register is envisaged to be linked with other sources of evidences, those ones which are preserved, collected by the International Criminal Court, domestic registers of damage, war crimes database. That is why it is important and even symbolic that the International Register of Damage will be seated in The Hague, the capital of justice. And we also welcome and are very pleased that the Council of Europe has the intention to play a leading role in the establishment of the Register of Damage. We realize that the key for effective operation of the compensation mechanism and the guarantee that all victims will receive the compensation is the sources of funding of the compensation fund. Therefore, it is fundamentally important for us that the frozen assets of Russia that have been blocked, frozen in many jurisdictions, and the assets of the designated persons remain blocked, are confiscated, and subsequently transferred to the compensation fund, which will operate within the framework of the international compensation mechanism. We also expect and discuss with the governments, with the parliaments, that in the near future our partner states will develop and adopt the necessary legal frameworks and procedures for the confiscation of such assets, their repurposing, and further transfer to the compensation fund. Ministry of Justice is working with the best lawyers to work out the legal grounds for seizure of frozen Russian assets, sovereign assets, and we will find the way how to do this. And we do expect that the governments of our allies will take the political will, political support to implement what lawyers will create. Another priority on the domestic level is imposition of sanctions on those ones who directly or indirectly support the war, and seizure of their assets through legal proceedings in Ukraine. And our parliament has introduced a law, a civil forfeiture law, enabling confiscation both of sovereign assets and privately held assets, the process of which are routed into the state budget for the reconstruction of Ukraine. So today, due to Ukraine's persistence on the battlefields and on the legal front, it allows us to change worldwide approaches and create new realities. It is very important for us, for the government of Ukraine, to provide the nationals with the effective compensation mechanism. And we do count on our allies' assistance and active participation in the establishment of the compensation mechanism, including confiscation of Russian assets through increase of sanctions measure and maintenance of sanctions until the compensation fund is established. The state is making all possible to implement the compensation mechanism fastest way possible. The state is making utmost effort to hold Russia accountable for the crime of aggression and make Russia pay for this aggression by its assets. That is why today we are here under the slogan United for Justice. Thank you.
Thank you. Thank you, Madam Deputy Minister. Indeed, very comprehensive overview of the mechanisms, of the vision, of the steps in relation to the establishment of the compensation mechanism. Indeed, Ukraine is a leader in the further developing the international law. And this is, unfortunately, it is related, it's due to the Russia's aggressive war. However, you are the ones that are creating the new rules and principles, and this is commendable. Thank you very much. However, in connection to that, Madam Deputy Minister touched upon the issues how frozen assets could be repurposed, seized and repurposed for the benefit of reparations and compensations to Ukrainian state and to the victims of Russian aggression and Russian international crimes. In this regard, I would like to turn to Markian Kluchkovsky, who is the member of the working group on the compensation mechanism, and zoom in a bit further what Madam Deputy Minister said. We all know that the compensation through the assets freezing and repurposing is connected to intricate international legal concepts. And many debate outside an international legal field that there are some issues that might first need to be addressed. And Madam Deputy Minister noted, for instance, the sovereign immunity issue. One could say, what about the confiscating of private assets? Could there be the issue on expropriation? So I'm sure within the working group, you are discussing those issues, and probably you are finding the answers to those questions. And could you discuss those? What are these building blocks? What are these key legal aspects that need to overcome in order to have this functional compensation mechanism in line with international standards? Thank you.
Thank you very much, Tina. Good afternoon, ladies and gentlemen, Your Excellencies. It's a great pleasure to be here. Prosecutor General Kostin and his team have put together an outstanding event. It's been referred to as the legal Rammstein. I like that, to be honest. It pleases me that my hometown is yet again at the forefront of development of international law. That is really quite fantastic. If you think that speaking after the Prime Minister is difficult, try speaking after the Prime Minister and the Deputy Minister of Justice. But I will try to zoom in on some of those issues. And, well, let's talk about money. The starting point of this discussion is that Russia will pay. There's no other way. I only can make this bold statement because I source it from international law. In international law, a state has a duty to make reparations for violations of international law, including an act of aggression. That duty is not conditional on that state's consent. Russia may say, no, we don't agree. No, Russia, we don't want to pay. It doesn't matter. It would be easier for Russia to pay, to just pay and start playing by the rules that the international legal order has put in place, but they don't want to, but that's fine. We'll take care of that itself. And a lot of the discussion today is, and throughout the weeks and months preceding, is about Russian assets, that they must be confiscated and given to Ukraine. What does that mean? It's not just a desire for Ukraine. We don't want just anybody's assets. We want to do what the law mandates. As I said, the law means a duty for Russia to make compensation, to make reparations. Ukraine proposes a comprehensive reparations system that will put that duty into effect in 3 stages, with the Register of Damages, the Compensation Commission, the Compensation Fund. The outcome of that process will be a set of decisions by a proper adjudicating body determining not only that the reparations are due, but determining the size, scope of those reparations, and who they belong to. In our view, as the Prime Minister has said, they belong to the people, the individuals who have suffered from the war, from businesses, the backbone of the economy that has suffered from the war, and the state itself that has suffered from the war. And when these decisions are in place, this is where the Russian assets need to go. Not just abstractly to Ukraine, but to the very victims who have suffered damage, loss, injury at the hands of Russian invasion. Now, when we talk about assets, we talk about at least 3 different categories. And each of them does raise a large number of difficult legal issues, not because that's not possible to do, but because it's never been done before. There has never been a challenge like that, not only a challenge to international peace and security, but a challenge to international law and to domestic laws of that nature, of that kind. And people just didn't think to come up with a solution in advance, because since 1945, we never imagined that a war like that would take place in Europe again. So we have to be a little bit innovative and think about ways to get hold of Russia's assets if Russia does not want to play by the rules. And the world has been incredibly innovating. When it comes to private assets, we know where to go. It's no longer a question which way to go to get hold of Russian assets. The world, the European Union, European countries, the US, Canada, United Kingdom are looking at the assets that have some sort of illegality to it. Russian assets that have some sort of illegality to it. It can be sanctions evasion, tax evasion, organized crime, anything that has an aspect of illegality to it. And procedures are being put in to confiscate those assets. We heard from Attorney General Garland yesterday about the first such case that has been completed in the United States, the $5.4 million confiscated, forfeited, I should say, from a bank account owned by Russian oligarch Malafeev. And a historic decision was made to transfer that money to the Department of State for use for the purposes of Ukraine. We always talk that the fundamental difficulty is to confiscate the first dollar. Well, that has been accomplished, and it's a big deal. It will take a lot of cases worth $5 million to make an impact. So our job, our task is to keep working with our friends to make sure that these procedures are streamlined, simplified, made more effective, so that it did not take a really gargantuan effort to confiscate the $5 million. If you look at the court case behind that forfeiture, and you see a long, long affidavit when an FBI agent prepared for the judge to, in the process of that case, you understand how much resource is being put into every single case. And that is going to be the same procedure for every bank account, for every yacht, every mansion, every expensive painting, and so on and so forth. So we really have to work on streamlining these things. And I'm very, very glad that that work is ongoing on both sides of the Atlantic, on both sides of the Pacific, I should say as well. The other side of the coin is the sovereign assets. Now that's a completely different issue. Those assets are not broken down into many categories. They're there, they're liquid. It's mostly reserves of the central bank, if you're being honest. And they just sit there. They've been immobilized when the sanctions have been put in place a year ago, and they just sit there waiting their fate. And those are the assets. That's the money that belongs to the culprit himself. Not proxies, not representatives, not oligarchs, not companies, the Russian Federation that is guilty of an act of aggression. How do we make it happen? How do we get hold of that money? There's, this principle that 20% effort yields 80% of results. We think that that's about the sovereign Russian money. The elephant in the room in a discussion about Russian money is the sovereign immunity. There's no avoiding that discussion. But another thing that's not there is that there is no provision in international law that says that sovereign immunity protects the assets of an aggressor state. It doesn't exist. Sovereign immunity as a concept of international law, I should say customary international law, is not a static concept. It evolves over time. Before the Nuremberg trials, the idea of putting a head of state on trial seemed absurd. No longer is. Until 1970s, the idea of attaching and seizing sovereign money yielded as a result of a commercial activity seemed absurd. Now it's common practice and an exception that is firmly written in every national law on sovereign immunity. Who is to say that sovereign immunity as a concept should be used as a shield to hide when it comes to an act of aggression and the perpetrator state committed an act of aggression? We think that it should not work like that. We also think that the domestic laws on immunity that exist in many countries where these assets are located also do not constitute a major problem. If you read those laws really carefully, the immunity is against judicial action. Jurisdictional immunity is against the action of the courts. It does not, on the letter of it, apply to an action to confiscate it by an executive or legislative action. And this is exactly what we have in mind. We don't want the states to just confiscate Russian assets. We want to make those assets available for compensation to Ukraine on the basis of a claims commission decisions through the mechanism that has been described today. And there's a fundamental difference between the judicial confiscation and that kind of confiscation. It's clear that it's not just simple as that to, just snap fingers and confiscate these assets. Laws have to be passed. And we're glad to say that those initiatives already are taking place. On the eve of President Zelensky's visit to London, a bill was introduced to the UK Parliament about repurposing of Russian sovereign assets. There are legislative initiatives in the United States. The European Commission has drafted up an options paper in December outlining the ways Russian sovereign assets could be used, and the Swedish presidency has formed a working group to further study those options. This train is moving, and it will not stop until Russia pays for what it did. There's a couple of words on the third small category of things. These are the assets that are private in formality but state-owned in nature. Those are the assets of Russian state companies. They are this gray zone that is comparatively rarely discussed. It's neither covered by the sovereign immunity, nor is it covered by the protections of private property and European Convention on Human Rights and things like that, because state corporations, state assets don't have human rights. And we will have to take a good hard look on those assets to see how they can be repurposed for the benefit of the reparations process. In the end of the day, that long journey has already started. You've heard yesterday President Levits, you've heard Minister Hoekstra, you've heard Commissioner Renders, you've heard the Speaker of Ukrainian Parliament this morning. The register of damage as the first component of the comprehensive compensation mechanism is a reality. It will happen. That train is moving. It will take some time to get it done. I think somebody said earlier today that international law is never fast. But considering the amount of progress that has been achieved over the past, 9 to 10 months really since that work had started, we are confident that there will be a lot of news and a lot of good headlines about compensation to Ukraine. Thank you.
Thank you very much. Indeed, Mr. Krichowski, it's a very interesting take and innovative approach to something that so far has never been done. It will, as you say, the train is moving and it will have tangible results, hopefully in the nearest future. So with this, we've seen the audience has seen the approach or the vision of the government as to the compensation commission. Now I think it's a good time to move a bit to international settings, to see the international standards on the asset seizing, freezing, seizing, compensating, or repurposing, and then later look at the different operation frameworks and mechanisms that are in the US, in the European Union, as well as in Ukraine in this area, and how to see how to enhance the international cooperation. And with this, I would like to move to Mr. Christos Giakomopoulos, Director General. Glad to have you on the panel. The Council of Europe has been the trailblazer in developing rules and principles on seizing, freezing, confiscating tainted assets, especially in criminal law field in Europe. Now, less than 1 month ago, the Secretary General also noted the readiness of the organization to be an active participant in the establishment of the register of damages. In this light, how do you see the role and the objective of the Council of Europe in the seizing and confiscating the assets and their use for the benefit of Ukraine and Ukrainians?
Yes, first of all, I would like to thank you, Tina, for changing the topic, because after the Prime Minister, the Deputy Minister of Justice, and Mr. Klukovsky, I would not be able to say anything new about the compensation mechanism and the legal problems that are there. Let me just start by saying that indeed the Council of Europe is willing to play a leading role in the issue of the compensation mechanism by establishing, together with others, of course, the register. And this is not because the Council of Europe has had suddenly this idea, but because it is a rule of law organization. And as you rightly said, I mean, when you have an illegal action which causes damages, there is an obvious need to provide for the reparation and the redress for the damage caused. The key issue, as you rightly said, is who will decide that the action is illegal, and therefore there is a need for this compensation commission that will have to have an international legal basis as wide as possible. And this is very much, of course, linked with the fact that it's not only the reserve funds of the funds of the Russian Federation's reserve that are in Western banks, but also funds of every African, Asian, Latin American state. So these are aspects that need to be taken, of course, very seriously into consideration. Now, asset recovery. I mean, the asset recovery is an issue that has been difficult all the time. It has become not only difficult but hot today because of the amounts that have been frozen in Europe, in particular, because of the aggression by Russia against Ukraine. And I think that this will remain a very hot topic in the future. I would like just to signal that from the outset, there is a presumption, or at least a suspicion, that parts of this money that is now frozen is the result, and I'm talking now about the monies that of individuals, actually, of individual persons, are related to money laundering, to corruption, to crimes more generally, and that they have been perpetrated by people who have been affiliated in one way, directly or indirectly, with the regime that has carried out the aggression. And I think that this is something that we need to take seriously into account, because it's not a new feature. It is something that has been at the origin of all the process of confiscation of assets everywhere. So it's not something that we invent completely. It is a normal, let's say, a normal consequence of the legal thinking that has prevailed over the last decades, at least, in international law. I'm making this because it is very often that, and it has been documented, by the way, that the authoritarian regimes all over the world sustain themselves through this type of crimes. Blocking the corrupt actors from the legitimate markets is not something that is extraordinary. I mean, it's something that we have conventions for that. We have money laundering conventions. We have anti-corruption conventions that deal with these issues. And this has been the crucial aim of all these avenues. So the assets which are currently frozen in Europe and elsewhere through sanctions could and should have been seized and confiscated, possibly even before the aggression, if I may say so. Of course, the aggression makes the things necessary, but if we think more broadly, I mean, there was already, there could perhaps be, but not to be very definitive on that, but a proper application of anti-money laundering legislation could have led to the confiscation. Yes, I mean, as we said, vast amounts of criminal proceeds have been generated as a result of this type of crimes, and they have deprived the societies from their natural development, and they have deprived the people for having access to the wealth of the country. And quite often they have led also to a democratic backsliding, and the democratic backsliding leads to violations of international law, in extreme situations, aggression. So I think that we are in the area where these phenomena are could be approached in a traditional way. I'm not talking about the sovereign, that just to be the sovereign assets. Effective confiscation. So effective confiscation of criminal proceeds is the final step of the criminal justice chain, the confiscation. It is also the most the weaker of this chain. Why? According to international statistics, let's say, and reports, the states confiscate 0.5% of the proceeds of crime. In some cases, 1.5%. The most successful country is New Zealand. They managed to confiscate 7%. That's not much. There are reasons for that. Some countries have managed to do this through the non-conviction-based confiscation. These are new tools, civil forfeiture. And this is an innovative and perhaps a necessary understanding of where we need to go as a tool. The second point that we see is that whenever we have confiscation, it is very rare that the assets are returned to those who have lost the wealth which is created by the crime. It's actually only 3% of the proceeds that are confiscated are returned to the right holders, let's say, moral, if you want, right holders. So I think that this is also a thing that needs to be taken into account. It has actually led even to more serious economic disparities between those who have the capacity to confiscate and those who do not have this capacity to confiscate. From this perspective, the decision that you have referred to from the United States is absolutely exemplary. Exemplary in the positive sense. Now, one of the reasons that this money is not returned to the countries that where these monies come from is that they may not be used for the social purposes for what they have been foreseen. that they will be again used by corrupt officials and that they will be again introduced in criminal networks. So it is on the basis of these considerations, the lack of innovative tools to go for confiscation without criminal conviction, the need to go for to renegotiate, if you want, the return of the confiscated assets to the places where they come from, and also the need to monitor the way these assets will be used, that the Council of Europe is presently thinking of implementing the conventions on the confiscation and seizure of assets and money laundering and financing of terrorism. The Warsaw Convention from 2005, and we are about to launch a new revision of that. What are the main elements, which are already in the Council of Europe arsenal on confiscation? I would say that the freezing of amounts by financial intelligence units and not by courts, because this is extremely important. So the freezing by financial intelligence units and the reversal of the burden of proof as part of the non-conviction-based confiscation. Non-conviction-based confiscation, we may wonder whether this is compatible with presumption of innocence, for instance, just to say one of the, because this is one of the main points that are made, and this is one very strange conflict or tension, let's say, between, in the Council of Europe, between those who work on fighting crime and those who work on protecting human rights. But I think that there is an equilibrium that can be found in this respect. Jeremy McBride made a very interesting opinion on the Ukrainian law about this on this topic several years ago. I think it is interesting to come back to it. But it is important sometimes to be able to get hold of this money when the level of the crime, for instance, the level of proof, the level of evidence that is required for a crime is higher than the elements that are available. Or when, for reasons of statute of limitations, you cannot reach the conviction. So there are areas and reasons to go for it. So this will be the first part of what we would like to put in place. The European Union is working, all this is already achieved in the European Union, let's put it clear, but it's already working on revising the directive, which is on the basis of this. Enhancing the asset sharing arrangements is the other part. How to negotiate with a country which proceeds with the confiscation, so that this is not only the benefit of the country that has confiscated. I think that this is another aspect that needs to be decided, and an obligation to enter into a kind of asset sharing negotiations on the basis of a number of principles that could be developed. And thirdly is that the returned assets are properly managed by those who have the obligation or take the benefit of these assets, the return of these assets in the recipient countries. And I think that from this perspective, let's say, to enhance the trust and the credibility of the receiving state, it is important to have a kind of international monitoring. I think that this will make will facilitate the return. And that is one of the elements that we work on today. I will stop here, and thank you very much. I tried to avoid the points that you made before. I don't know to what extent I succeeded, but I can come back if you insist. Thank you.
Thank you, Director General. I think it was a very insightful look into the work that Council of Europe is doing and the planned activities, but also was very interesting to know that sometimes we do not, governments, countries, member states do not use the available resources and mechanisms, so-called the traditional ones that are there already in the convention, and we need sometimes a catalyst, something to push for their invocation in the work of the governments. And thank you for that, for reminding that this point as well. Now, if I would turn to our two panelists, which are online, and let's see how what are the international operational mechanisms in the United States, in EU, as well as in Ukraine, of how the asset freezing, asset seizing, repurposing takes place. And first, I turn to Mr. Andrew Adams. Are we audible? Mr. Adams, can you hear us?
I hear you. I hope I'm coming through okay in the room.
Yes, perfectly. Thank you. And just want to introduce that Mr. Andrew Adams is one of the prosecutors who has extensive experience in dealing with the Russian handling the cases of Russian organized groups. And now, since March 2020, he's the chair of the Klepto Capture Task Force, the task force which was established under the United States Department of Justice, an interagency task force, and that has been working quite actively. And as has been already mentioned, we have significant results of your work and work of your group, Mr. Adams. And I think this first case, once it comes to the logical conclusion of the assets, seized assets, forfeited assets returned to Ukraine, it will send a very clear message to all the facilitators of Russian regime, those that support, aid and abet, that the restrictions and the accountability is not just a mere fictitious notion, but actions do have consequences, and these actions and these consequences could be will be also monetary consequences. So, in this regard, Mr. Adams, I would like to turn to you with the two questions, if I may, or two limbs of the questions. The first one is, it's 1 year since the task force is working. Could you overview the work of the task force? What has been achieved? What are the let's say, the benchmarks to achieve? And second, in light of the first case of forfeiture and the return of the proceedings of $5.4 million US, I would like to ask you, what would be the modalities of the further repurposing of these assets to Ukraine? Will these be modalities and mechanism established, or will you go on case-by-case basis? Thank you.
Thank you. Thank you very much. And it's really an honor to join everyone here today and to offer at least some modest contribution to an enormous undertaking. I'll start with giving some context for what we in the United States have done over the past year and focus really on what our two parallel priorities have been and where we see those going in the future. And then I'll turn to the asset transfer question and the law that was put in place last year. So briefly on the task force, we sit in the Department of Justice, and that's distinct in the United States from our Treasury Department, which is the body that primarily issues sanctions and essentially freezes assets. What the Department of Justice is focused on is the judicial forfeiture of assets, going through the process under established law to fully and finally divest anyone, including oligarchs, including professional money launderers, and others, of their ownership interest in tainted assets. As has been mentioned earlier today, our focus has been on assets where there is some nexus to crime, either the proceeds of crime or property involved in money laundering offenses. In doing that, we've taken, as I say, two parallel tracks for priority. The first I think of as sort of our early days short-term priority for seizing and freezing large, ostentatious, and often mobile assets that were likely to move swiftly out of the jurisdiction of the United States and, more significantly, out of the jurisdiction of our friends and allies who would cooperate with our requests for seizures and forfeiture, and into jurisdictions where that sort of cooperation is less likely, although perhaps not impossible, as I can turn to in just a moment. In that respect, some of the benchmark moments were the seizure of mega yachts in Spain and in Fiji, of bank accounts here in the United States, and bank accounts sitting in the EU and elsewhere, the freezing through warrants and ultimately process for forfeiture of real estate, including some quite nice real estate here in the United States and abroad, and other assets that were likely to either physically move or change ownership structures in opaque and obscuring and obstructive ways in early days. At the same time that we thought about this priority, which is in large part a move to lock down assets for the benefit ultimately of Ukraine, and to really galvanize prosecutors here and abroad on taking similar steps. At the same time, we undertook a second-tier priority, or second-order priority, that I think of as a longer-term priority, and one that ultimately may have a broader impact on the Russian economy and the Russian war machine. And that is focusing more squarely on networks and professional classes of enablers and facilitators who essentially make sanctions evasion and export control violations possible at large scale, and in some cases for whole sectors of the economy. We saw the beginnings of cases along these lines approximately 6 months after our task force kicked off. That coincides with the fact that criminal cases, as these are, tend to take longer to bring to fruition, which is why I think of this as more of the midterm project, which will become the long-term project. But we saw sanctions cases against professionals working for Oleg Deripaska in the field of real estate and art, for example. Saw procurement networks tied to military and dual-use technology, and that runs as recently up to 2 days ago when we announced our most recent export control violation case, touching on 2 individuals in the middle of the United States in Kansas, charged with providing aviation technology and avionics to Russia in violation of our export control laws, which is, I think, to be expected to be a continuing priority for us going forward. To that point, I'll emphasize, I think, that going forward, we will be looking for opportunities for additional massive seizures, and we'll do that in cooperation with our foreign partners. We've found a lot of success in thinking broadly about how the United States can be useful and how the United States can define its own success. To that end, we have been, I think, more aggressive than most prosecutorial efforts in the United States in being public about showing our work. We are unsealing affidavits early. We are aggressively providing information to partners around the world so that seizures, freezes, and criminal cases can be brought in other jurisdictions, even if the United States is not taking the lead on those cases. And to empower the private sector. We'll, in situations even where an asset may be found in a jurisdiction that is unlikely to be immediately cooperative with us, at least in the current political environment, we are nevertheless taking the opportunity to unseal information, disclose networks of shell companies and professional enablers so that the private sector can read those documents and understand who should be avoided, what transactions beyond our own case should be denied, and really looking to leverage a sense of rule of law and pride and compliance within the private sector to our benefit and to our advantage, even in situations where our warrants may sit unanswered for some period of time. Let me turn briefly also to our asset transfer authority, which has come up a couple of times, and it is certainly true, as has been remarked, that in the grand scheme of damage and terror that has been wrought in Ukraine, this is a drop in the bucket. It is important for us, I think, in the United States to understand that our ability to provide some amount of compensation through these mechanisms is limited and modest and doesn't come close to truly addressing the horrors that exist in Ukraine today. That said, I do think that it's important for a couple of reasons that we've taken these steps. The first is one, that any dollar that can go towards compensation and reparation is important, as modest as it may be. But the second is really a signaling of possibility, what is possible, and what is and what we in the United States will continue to pursue. What I mean by that is that it is possible, and in fact, I think it is imperative to have systems in place to take tainted proceeds, take tainted property, and adhering to the rule of law, adhering to strict procedures to protect property rights and due process, to protect innocent owners and third parties. It is possible and it is imperative to have a system that will nevertheless allow for the full and final divestiture of tainted assets. It is not contrary to international law. It is not contrary to due process. It is, in fact, well established in the United States and also in many multinational and international conventions that this be a process available for addressing criminal activity and divesting criminal proceeds. It's not a silver bullet by any means, but I'm hopeful that these initial transfers from the Justice Department to our Department of State that will occur in the coming weeks following the initial authorization will be a model by which we can scale out these kind of programs beyond the United States going forward. And with that, I'll pause and pass back over. Thank you.
Thank you very much. A very thorough analysis and input of how the task force is working. And I think all in this audience was glad to hear that the first successful case will serve as a model for the future coming instances of repurposing of the assets. So thank you very much for that, and good luck in your work. And now we would also move to see how the task force, Freeze and Seize task force, works within the European Union, and we should have the team leader of the task force, Mr. Fabio Giuffrida. Yes. Good afternoon. Good afternoon. Mr. Giuffrida, it's glad to see and hear you. And your task force also was created a year ago, in March 2020. And you also have quite a challenging role in coordinating the measures among the EU member states, applying the sanctions in relation to on Russian and Belarus, as well as Belarusian individuals and companies. And therefore, you are uniquely equipped to give us the insider's look of how the task force is functioning and what are the achievements and challenges. In this regard, exactly this is my question. Could you, within this, throughout this, the work of the 1 year, could you assess the work of this 1 year of the task force? What have been the achievements? What are the hurdles that you are facing? And how do you think, what is the approach, what would be the approach of European Union in relation to the transfer, the repurposing of the assets and creation of these type of mechanisms? Thank you.
Yes, thank you very much. I hope you can all hear me. And well, first of all, I would like to indeed thank you for the invitation. It is really an honor for me to be here, although unfortunately only virtually. Indeed, just a few words on the Freeze and Seize Task Force, and then to explain what our objectives and what are our achievements so far. So 1 year ago, the European Commission, under the lead of Commissioner Reinders, created the Freeze and Seize Task Force. The Freeze and Seize Task Force has two main objectives. The first one is to enhance the cooperation among the member states in the enforcement of sanctions. And the second objective of the task force is to explore to what extent criminal law measures, such as, for example, confiscation, which has been mentioned today already. So to what extent criminal law measures can play a role here in this context to contribute to the reconstruction of Ukraine. And precisely because of this dual objective of the task force is composed by different commission services. So not only the Director General for Justice, so DG Just, in which I work, but also other Directorates General, such as the one for Financial Stability and Financial Services, so DG FISMA, but also the Director General for Home Affairs and for tax-related matters. In addition, the task force works with the 27 member states and also European Union agencies such as Europol and Eurojust, as well as the European Public Prosecutor's Office participate in the task force. The task force has met already 19 times over the last year to discuss issues related to these two different objectives of the task force. And we had the first meeting in person a few weeks ago, and we had the honor of Prosecutor General Kostin joining us for the opening remarks. The task force works in subgroups which are competent to delve into specific issues that are of the essence in advancing the role and the efforts of the European Union when it comes to sanctions, but also when it comes to the possible use of frozen and immobilized assets, and indeed when it comes to using these assets to contribute to the reconstruction of Ukraine. So we have one subgroup that deals mostly with matters concerning asset freezes and reporting, and that subgroup is bringing forward discussions on issues such as, for example, the reporting of measures that the member states take in the implementation of sanctions, but also in bringing forward discussions on issues such as beneficial ownership, for example. which has turned out to be one of the biggest challenges in enforcing sanctions. Thanks to the work and together with the colleagues of DG FISMA, we have now an estimate of approximately 20 billion private Russian assets frozen in the European Union. Then we have another subgroup in the context of the task force, which deals instead with the exchange of best views when it comes to criminal investigations and confiscation. And in the context of this subgroup, a number of initiatives have been taken. The first one is an external study supervised by the colleagues in DG Home, which aims to map a number of companies in the European Union and beyond, and try to understand behind which of these companies there is ultimately a Russian person who is currently on the European Union sanction list, and these data will be shared with the law enforcement authorities for the appropriate follow-up. But in the context of this subgroup, also some initiatives have been launched or supported, such as, for example, the Operation Oscar by Europol, which is an operation that is meant to coordinate and the investigations into violation of sanctions and support the investigations into violation of sanctions by competent national authorities. And similar initiatives have been taken by the other union agencies, so Eurojust, which is instead competent for the support to the national prosecuting authorities when it comes to crimes such as, indeed, violations. Then we have another subgroup in the context of the task force, which instead tries to tackle these issues from the perspective of tax enforcement. So in this case, what this subgroup is working on is the coordination of the activities of tax authorities of the member states, which are currently double-checking or cross-checking better the national tax registers against the EU sanctions list, to see whether and to what extent people that are included in the sanctions list are also included in the tax registers of national authorities, for example, because they've been involved in previous tax investigations or audits or tax irregularities. And then we have one last subgroup, which instead we our discussions on the possibility to pool the resources coming from confiscation and using them for the benefit of Ukraine. So as you can see, the task force tries to look into this aspect, so into how we can contribute to the reconstruction of Ukraine from different perspectives. From the perspective of sanction, of criminal investigations and confiscation, and from the perspective of tax enforcement. In addition to that, the task force has been deeply involved in a number of legislative initiatives that the European Union has adopted recently, and I would like to flag here one proposal which has been tabled by the European Commission at the beginning of December last year, which is a proposal by which the European Commission has proposed to harmonize across the European Union the crime of violation of sanctions. As you know, violation of sanction is already a criminal offense in a number of countries, including in a number of European countries, but it's not yet a criminal offense in all the European Union members. And the European Commission has decided to tackle this gap and to try to bring forward enhance the situation in the European Union and ensure that the violation of sanction is a criminal offense in all the member states. Once this proposal will be adopted, and together with the other proposal that was mentioned before by Director General Giacomopulos of the Council of Europe, the proposal on the confiscation, So once these two proposals will enter into force, on the one on violation of sanction and the one on confiscation, it will be much easier in the European Union to proceed with the confiscation of assets, and then as a second step, indeed, we use them for the benefit of Ukraine and its reconstruction. The two last points, and then I will stop, but happy to take any question you may have. The first one is indeed that, as was mentioned by Advisory Kluchowski, the task force and the commission in general is now intensively looking into the issue of how we can use the frozen and immobilized assets, notably the ones of the public assets of Russia, and how we can use them for the benefit of Ukraine. And to this end, we have prepared an option paper at the end of last year, and now discussions will continue with the member states in the context of the ad hoc working group that has just been created in the Council and that was mentioned before by Advisory Kluchowski. The last point I want to make is that what we have realized across the last year is that the real added value of creating a task force in these exceptional circumstances is that really it is in this context that coordination and unity can really make the difference, can really have an added value to ensure that what we do all together is directed towards the same aim and that we can achieve it together. And I think this is, in a way, chimes very well with the name and the overall objective of the conference today and these days, United for Justice indeed. And in that respect, I would like to stress that the task force is coordinating on a regular basis with our international partners, of course, first and foremost, Ukrainian authorities, and I see in the panel Vlad, with whom we are in contact, but of course also our US counterparts, and indeed I was happy to see in the same panel today Andrew, but also with the G7 task force that has been created with a similar aim, the so-called REPO task force, but we are in touch also with other authorities across the globe. So I would stop here, but happy to take again any question, and thank you very much again for the invitation today. Thank you.
Thank you, Mr. Giuffrida, for the insightful overview of the multifaceted work of the task force. We all have the very long road ahead of us with a lot of benchmarks and objectives, and the proposals that you touched upon during your intervention, the adoption of those proposals will definitely assist in the overall objective of which is of today's panel, to limit the possibility of evasion of the sanctions, allowing action, establishing the framework for the assets, tainted assets, to be confiscated and to be returned, to be directed to Ukraine. And at the end of your intervention, you noted the importance of the international cooperation, including the incorporation with similar task force, and this actually leads us to our next panelist, leads us to the Ukrainian task force. And I would like to address Vladislav Lasyuk, who is the deputy head of Ukrainian task force, who has been quite active in its functioning. And Vladislav, I would like to ask you, could you discuss what are the modus operandi of the task force? What are the short, mid, and long-term objectives? And how the international cooperation with your colleagues is going?
Thank you, Tina. My name is Vlad Vlasuk. I know this panel has been too long so far, but it's gonna be just 2 speakers, so just be patient, listen to us. Thank you. Yes, I know that this is the Task Force Ukraine, and what I realized during 2 days conversation that there is no much understanding, clear understanding what is the difference between Ukrainian task force, the American task force, the European Season 3 task force. And I mean, yes, we are all doing the same thing, but yet we all have our own ways of doing so. So let me first just explain a little bit clearer. So what is the mandate of Ukrainian task force? So yes, it was set like a year ago. And the first half year of the activities of the task force was probably a little bit in the wrong direction. But since September, we changed or shifted the concept of Ukrainian task force. And it is now a little bit more based on their objectives, which is so clear. The clear objective of the Ukrainian task force is this: to provide a solid legal basis for confiscating assets of mostly Russian tycoons, and those assets must be placed across foreign countries. So this is the mandate of Ukrainian task force: to confiscate the assets and to get it back to Ukraine. Just one maybe recent example of what it is this way. Last week, the prosecution service, together with the court in France, reached a decision which was related to the nice villa of Mr. Rashnikov, a very big guy in Russian defense sector. So he used to have this beautiful villa, estimated at least for 17 million euros. And it was confiscated for exactly perpetrating an economic crime of money laundering. So this is exactly the way. What we've been doing so far for the half of a year now. First, we made a short list that included 120 targets, roughly 100 of Russians and maybe 20 of Ukrainians, including Boguslav and some other guys. Then we made a short list of 25, and finally we reached to the super short list, which is 6 names. I would name only Deripaska, who is among those 6, just because it was already sounded here. But you probably can take a guess who are those other guys in the super short list. So we have different law enforcement agencies in Ukraine. They're doing investigations of the crime committed by those people within the territory of Ukraine. Those crimes mostly of economic nature, so economic crimes. And the Task Force Ukraine, which has their delegates of different law enforcement bodies or agencies in its on the list, we are kind of coordinating the efforts. So the Task Force Ukraine is made under the auspice of the Prosecutor's General Office. And we are making I would say, the fast track possible for those criminal investigations, which are the priority targets for us. At the same time, we've been doing a lot of international cooperation. I would name first exactly the Freezing Seas Task Force within the European Union, and I would name also the klepto capture of Andrew Adams. So, and there are 2 probably main or parallel tracks within the Task Force Ukraine. First, it is to conduct quickly their criminal investigations to reach the intermediate decisions, including the arrest, then to get the process of international legal cooperation. And that is what is exactly going on with the Boguslav case and with the Zhevago case. And in a parallel, we've been doing an active searching for the assets. So in order to be able to confiscate the assets, we have to identify and to trade those. So this is like another major part of the work of Ukrainian task force. We've been supported massively by some international programs and partners. Thank you for them. And so now I'm swiftly coming to the part you all wanted to hear. It is how to help Ukrainian task force to reach its objectives. So I would start with the objective of the looking for the assets. So we managed to get some assistance to work more efficiently on the looking for the assets which belong to our targets across the European countries and in the US and in the UK, in some other jurisdictions also. But this is also always a good idea to help us to look for the assets. Then it must be international cooperation. And by that, I mean not only with the task force, their counterparts, but also with the relevant law authorities of different countries, including the mentioned OSCAR, including with the mentioned Interpol, Europol. Their primary objective in this area, it is to set the links. Because many Russians and have been very creative in a way of setting webs or networks of proxies, family members, other guys, to register the assets in their names, which makes it really, really difficult first to convict some of those guys in Ukraine for committing criminal crimes, and then to build a bridge, build a link to their assets which might be registered in some other names. And at the same time, we've been cooperating actively, especially with the Andrew Adams teams, especially on the mentioned Deripask and some other criminal cases. So we've been actively investigating the crimes committed by them, because those crimes, almost all of them are of a large scale, including this international cross-border element. And this is always a good idea to link their efforts within different jurisdictions by different organs. So this is what we have been doing for half a year. We have some optimism about reaching very soon very concrete decisions within those criminal investigations in Ukraine, which might be in turn be a very good and solid basis for realization. Sorry, I'm really trying. Sorry, but you're really disturbing. Sorry. So I've been telling that we are trying to reach those decisions and then to use the means of international legal cooperation, and by that solid ground of criminal convictions here in Ukraine to reach for the assets in the different jurisdictions. I know, of course, that there are a lot of different ways, including the mentioned criminalization of violation of sanctions. Me, as a guy who is also doing a lot on the sanctions track, is very much in support of that, but this is at least some period of time which might come before we will be able to criminalize those and to penalize those across the European Union. It is also a good idea to support the adoption of a relevant law, which is going to be the law on criminalization, the violation of sanctions in Ukraine. It is somewhat under-processed in the committee of the Verkhovna Rada. So those are, and of course I have a lot of respect to the job which is Minister of Justice doing, because this is just like a very different way of reaching to the same result. And they also, of course, they include not only private assets, they would go for after the sovereign assets, which is just a great idea. So this is what is going on within the Task Force Ukraine. Again, two main things. First, it is looking for the assets across the different jurisdictions, and second, proceeding actively with the criminal investigations here in Ukraine. So this is it, and we are looking very much for further support and cooperation. Thank you very much.
Well, I think you pretty nicely summarized the two main objectives and two main directions of the work of the task force. And thank you. And something that you've underlined is probably is the question to the last final speaker. It's Ivan Horodetsky, who is the Ukrainian lawyer, member of the Bar Association, who is very actively working with the civil society on the issue of asset tracing. And this is what actually Vlad underscored, how important it is to assist the task force in searching for the assets. And in this regard, my question to you, Ivan, would be how you see the role of Ukrainian civil society and lawyer society, legal society, in assisting Ukrainian authorities in tracing the assets, and what have been your experience in this regard?
Thank you, Tina. Thank you so much, all the audience who is still here. Next time I will try to become a prime minister to speak first, not the last. This is really aptly and very good question. In fact, the issue of tracing Russian assets and their further confiscation is one of the most important, and at a certain point will become a key issue for the whole process of the compensation. Today's speaker, Ruslan Stefanchuk, emphasized that on the problem of availability of the resources to pay the compensation, and it will be faced. Also, in May of last year, in a position paper on the compensation mechanism of Ukraine, Markian Kluchkovsky, Patrick Pearsall, and Chiara Giorgetti stressed that no mechanism can be considered fully successful without adequate funding for the payment of compensation. And I can only fully agree with this, that we can elaborate ideal comprehensive mechanism, but we need to trace assets and confiscate them in order to pay, because the final aim is not to build a perfect compensation mechanism. The final aim is that victims should get compensation. It should be recognized that the key role in the process of the asset tracing and asset recovery belongs to the Ukrainian government and law enforcement agencies and such working groups as Vlad is member of, and as well as our allies. Of course, we all wish that these processes were faster, but we should not do not underestimate their work in this process. However, civil society and lawyers are also very actively working in this direction in Ukraine. I can mention Dnistransky Center, which I represent, who runs Compensation for Ukraine project, Ukrainian Bar Association, which has a special working group on this issue, Institute of the Legislative Initiatives, which runs Confiscation Tracker, very interesting project. Also, I would like to say thanks to donors who support these actions, to the International Renaissance Foundation, to the USAID Justice for All project, to the European Anti-Corruption Initiative, many others. So this regard, international community and civil society in Ukraine are very actively cooperating. What is the role and could be role of the civil society and legal practitioners? I can consider it in two main dimensions. First of all, it is a direct assets tracing. This work may lack systematicity and coordination in the case of NGOs and legal practitioners, but still crowdsourcing can become an important additional element for this process as a whole. After all, the most famous revelations of criminal assets in the last decade were done by media and NGOs, and this shows us an importance of role of NGOs, civil society in general. And also where some governments or politicians may lack the will to expose some certain assets or to take certain decisions, civil society may be more assertive. Secondly, it is a public awareness that civil society, NGOs, legal practitioners may inform and communicate to the society as a whole the main issues, the main problems which are faced in the process of asset tracing, confiscation and compensation in general, because year to year, month to month, week to week, there will be more and more requests from the society, from the citizens, from the victims, where, when, where and how we can get compensation. These processes are politically sensitive, and it is understandable and clear, especially in the conditions of ongoing aggressions. And therefore, lawyers, legal practitioners and civil society, NGOs, they can complement government activities. So in the situations when government task forces, they should keep silence, civil society can explain why and can explain certain actions and certain steps. I always repeat that the process of compensation to Ukraine will be long, complicated and difficult, and this is a reality of international practice. As my previous speakers of this panel mentioned, there are no established and comprehensive mechanisms yet. Also, it is important that on this way, civil society and lawyers should cooperate with the official track, supporting both supporting government actions, official actions, both with advice and criticisms, but not entering into unnecessary confrontations. Thank you for your attention, and I hope that I was comprehensive and clear enough. Thank you.
Thank you, Ivan, very much, and thanks for to the audience and to the speakers to stay with us. I think at the end of the day, two biggest takes from this panel is that we have to work together within the country as well as internationally to achieve the goals. We have to make a better use of existing mechanisms and don't shy away from developing the new ones and be innovative. And on my behalf, I just want to underscore that we as an international experts, we will, myself representing the USA SACHI project, we will be next to the Ukraine task force as well as Ukraine government in achieving your goals together with you. Thank you very much for your attention.
Thank you very much, distinguished speakers. Actually, we have only one point for today in our program. It will be the side event documenting international crimes by civil society and media. So we need a few moments to replace our chairs for our speakers.